I guess we could start. Good afternoon, everybody. I want to thank you very much indeed for joining us for this second session. I hope it will be as lively and as interesting as the first session was. I will now leave you in the able hands of Dr. Anne Wolf, the Director of Konrad Adenauer Stiftung Rule of Law Program for Sub-Saharan Africa. Dr. Anne Wolf, over to you as moderator.
Thank you so much, Charles. I'm very pleased to do this afternoon session as a moderator. And I also like to greet all panelists for this afternoon session. And we like to start after this successful morning event. We like to start today or this afternoon about some situations, talking about the situations in different South African countries. And we will start first with a presentation about the livelihoods and legal struggles amidst a pandemic, the human rights implications on the measures adopted to prevent, contain, and manage COVID-19 in Malawi. The presentation will be given by Professor Mwiza Jo Nkahata, and Mwiza Jo Nkahata is a Malawian lawyer currently working with the African Court on Human and People Rights in Arusha in Tanzania. He has, beside his studies, he also has a Doctor of Laws degree from the University of Pretoria, which he made in 2010. He has also holds of a postgraduate certificate in higher education awarded by the University of Pretoria and a diploma in the justiciability and enforceability of economic, social, and cultural rights from the Abo Academy University. He's a former Dean of Law from the University of Malawi and also a former president of the Malawi Society. I don't want to present all the others now. I will do that later. The presentation was actually prepared also by Mr. Anganile Willie Nifumbu, but this person unfortunately can't join our session now. So it's the floor for Professor Mwiza Jo Nkahata, and as Charles Fombart told us already in the morning, please keep your time. It's 15 minutes per presentation. That belongs to all presentations in this afternoon. Please keep the time 15 minutes, that we have enough time for questions and answers and discussions afterwards. Professor, the floor is yours. Please go on.
Thank you, Dr. Arnaud, and thank you to Professor Fombart for the invitation to be part of this discussion. Like was pointed out, we've developed this paper in conjunction with a colleague who is unfortunately not able to join us this afternoon, but who has sent his apologies to the organizers of this conference. Given the limitations of time, I propose that I quickly run through the paper. Some of the detail might not be immediately apparent during the presentation, but it will obviously come out when you read the paper itself. Our paper is on livelihoods and legal struggles in the midst of the COVID pandemic, looking especially at the human rights implications of the measures that have been adopted in Malawi to deal with COVID-19. To start with, let me highlight what seems to have been the initial irony about the.
Sorry, let me just interrupt you. Let me interrupt you one bit. Please, can all the participants mute their microphones? Please mute your microphones. Somebody has left the microphone on and is interfering with his presentation. Please go ahead.
Can I proceed?
Please proceed. Proceed.
Okay. Yeah. So I was saying that let me begin by shaping some context to how the COVID pandemic has developed in Malawi. Now, there's one thing that stands out in the way the government response has been shaped. Yeah. So, while the WHO declared the pandemic on 11 March 2020, Malawi's first cases were only announced on 2 April 2020. So on a time scale, Malawi joined the last 6 African countries to formally announce the cases of COVID-19. Now, the question here has always been whether the failure to announce cases earlier was because there were no cases in Malawi, or whether the failure was because of inadequate and limited testing. This has been highlighted especially because at the time that no cases were being formally registered, all neighboring countries in the region that share borders with Malawi had announced cases. And given that there's a lot of mobility between Malawi and those countries, it is very doubtful, and it does lend credence to the fact that probably there were already cases of COVID-19 in Malawi, even way before the government announced the first cases. Nevertheless, on 20 March 2020, the government declared a state of disaster. But you will note that they declared the state of disaster even before they had formally acknowledged that the country was registering any cases of COVID-19. So I think all this seems to lend credence to the fact that maybe the country had cases earlier than the government formally considered these cases. So our analysis focuses on the legal framework that has been employed by the government to respond to COVID-19. And we have tried to analyze the legality and human rights implications of some of the measures that have been put in place to prevent, contain, and manage COVID-19. Let me start by quickly trying to shape the legal framework that is in place in Malawi to deal with COVID-19. Firstly, of course, is the Constitution, because the Constitution of Malawi, like many other countries, declares itself to be the supreme law of the land. So any other law must, of course, comply with the provisions of the Constitution. Now, for the COVID response, there are, I think, 2 levels at which the supremacy of the Constitution is important. Firstly, is because any measures that are adopted by the country should not contravene the procedures that are in the Constitution for adopting laws. And secondly, substantively, any measures that the country has adopted should also not undermine any of the entitlements that are already contained in the Constitution. So at that level, the Constitution a priori already frames the manner in which the response to this pandemic must be crafted. Let me also quickly point out that the Constitution has recognized that there can be limitations and derogations to all the rights that it has protected, and the Constitution has quite a sizable catalog of rights. The framework for limitations under the Constitution of Malawi is similar to the framework under the ICCPR. So by and large, Section 44, subsection 2 of the Constitution requires that any limitation must not negate the essential content of the right at issue. It must be of general application. It must be recognized by international human rights standard and necessary in an open and democratic society. The Constitution has also provided that a state of emergency can be declared by the president, but only with the approval of the Defense and Security Committee of the National Assembly, and specifically only in times of war, threat of war, civil war, or widespread disaster. I think the one other thing that I could highlight about the Constitution is that it has also prescribed the parameters for making subsidiary legislation. And the key here is that although all legislative authority is vested in the National Assembly, Parliament, if you wish, the Constitution has said in certain circumstances, the executive or the judiciary could pass subsidiary legislation. But subsidiary legislation must comply with some certain fundamentals, including the fact that it should not exceed the authority of the parent legislation. Specifically in relation to public health, there are two laws which are critical here. It's the Public Health Act and the Disaster Preparedness and Relief Act. I will not go into too much detail, but let me highlight that the Public Health Act was enacted in 1948. So it is essentially a relic from colonial times. The approach that it has adopted has been correctly, in our view, criticized for being obsolete and for propagating a 19th century understanding of diseases and ways of controlling diseases. The scheme under the Public Health Act envisages that you have what are called notifiable diseases, formidable epidemic, or formidable endemic diseases. And the response thereto is crafted by the minister declaring a particular disease to be a formidable epidemic or endemic disease or a notifiable disease. And surprisingly, of course, on the list of diseases under the Public Health Act, COVID-19 is not included. The Disaster Preparedness and Relief Act, for purposes of the present discussion, I think permits the president to declare a state of disaster. Now, the state of disaster can be declared by the president if there is a crisis of a nature and extent where extraordinary measures are necessary to assist and protect persons in Malawi that might be affected by that disaster. The procedure requires the president to declare the state of disaster, to have it gazetted, and then a response mechanism is triggered. Again, let me say the Disaster Preparedness and Relief Act predates the Constitution in Malawi. Nevertheless, because of the supremacy clause of the Constitution, its provisions must be interpreted in a way that complies with the Constitution. Allow me to quickly move on to the response that Malawi has had specifically in terms of the COVID-19, which we think has been a story of fits and starts. So firstly, the president on 7th March 2020 established a special committee on coronavirus. I will be referring to this as the committee. Along the way, in April, that thing was renamed and called a task force, and a few other, its composition changed a bit. Then on 20th March is when the state of disaster was declared for a period of 3 months, and measures were announced to follow that through in the state of disaster. On 1 April 2020, the Minister of Health, apparently acting under the Public Health Act, declared COVID-19 a formidable disease. Now, if you follow the scheme under the Public Health Act, once a disease is declared a formidable disease, the minister is empowered. The minister is empowered to declare an affected area that has been affected by that formidable epidemic disease, to isolate it, to say this is the area that has been affected. Once that has been done, then the minister can make rules for the containment or management of that particular public health crisis, including how the dead are to be buried and how the sick are to be accommodated and how medical aid must be distributed. Under that scheme, the responsibility for coordinating all that falls on the local authority of the area in which the epidemic or endemic disease has been declared. So what you will start, pardon me, let me just also say that the public health coronavirus rules of Malawi were promulgated on 9 April 2020. And after they were promulgated, it was announced that there would be a lockdown for the whole country from 18th April to 9 May 2020. But the lockdown itself was never implemented because some people went to court, challenged that, and the High Court issued an order stopping the promulgation of the implementation of the lockdown. However, 2 months down the line, on 11 July 2020, the task force, the presidential task force that I mentioned earlier, purported to introduce a list of measures to again deal with the pandemic. These measures, surprisingly, were very close and very similar to the same measures that had been stopped under the intended lockdown. Now, of course, many people pointed out the fact that the government was reintroducing the lockdown without declaring a lockdown. And in a very strange twist of events, the Attorney General wrote the task force to tell them that they could not impose these new regulations before the court had finalized the case challenging the lockdown. Now, when we wrote the paper, we said that the situation in Malawi was still evolving. And true to, I think, what we said, last Friday on 7th August, the government adopted new rules, revised regulations on dealing with the coronavirus pandemic. We are yet to do a full comparison of these new rules and the regulations that we premised the paper on. But we still think there's more that will come in the future in relation to how the government is responding to this pandemic. So far, the government response has triggered 3 cases. The one case, and all of them have been judicial review cases. The first case involved some Chinese nationals who were trying to enter the country, who were stopped from entering the country by immigration officials. This case has yet to be concluded, but the court issued an interim order preventing the immigration department from deporting these Chinese nationals. Although the court has not conclusively disposed of the issues, the court attempted to hint at some of the things that the government was getting wrong from a legal perspective in the way it was responding to the COVID pandemic. One of which was the fact that the COVID rules of the time by themselves may have exceeded the parent legislation that authorized the minister to issue those regulations. The second case was brought by students from the University of Malawi who were challenging the closure of one of the university colleges due to the measures that the government had adopted to deal with the pandemic. The court in this case refused to grant leave for judicial review, but it reasoned that what was at play in Malawi was a state of disaster, not a state of emergency. Notably though, if you look at the judgment, it is clear that the court acknowledges that there is not very sufficient clarity in Malawi between a state of disaster and a state of emergency. In the words of the court, the country should have a comprehensive discussion on this important matter of law so that we have clarity on what exactly is a state of emergency and what is a state of disaster. The last case that has dealt with this was brought by various members of faith groups and others. And they also challenged the intended lockdown. Their major grievance was that the government was imposing a lockdown without making adequate provision for marginalized groups to be properly protected during the lockdown. When we analyze all these cases, our conclusion is that Malawi's response to the COVID pandemic, at least from a legal perspective at the moment, has yet to be crystallized. It is still developing, and there's more that we can expect on this regard. More so, we think it is a response that is skating with the question of legality. Some of the things that have been done, and we do go into some detail in the paper, border on an excess of legality, an excess of authority, in the sense that the authorities have either exceeded their powers or in other cases have acted without their powers and created structures that are not supported by what the law permits them to create. Key here is that it is probably the case that the coronavirus regulations that were promulgated in Malawi are illegal, since they were made under a law which in our view does not authorize the government to make the law that they did. I think because time is running out, let me quickly conclude by getting to our argument on the livelihoods and human rights implications of the response in Malawi. So I think there is acknowledgement in Malawi that the COVID pandemic is a threat to life, is a threat to lives of Malawians. But perhaps there is not an equal acknowledgement that within human rights there can be a middle way of sorts that can be found, and through this middle way, you could address the challenges being brought about by the pandemic without necessarily compromising human rights. In our view, we have taken in our paper, we have taken the right to economic activity as a perspective for highlighting some of these challenges, because we think the right to economic activity has implications on other rights that have a direct bearing on people's livelihoods, such as the right to food, the right to work, health, housing, and education. So the Constitution provides for the right to freely engage in economic activity and to pursue a livelihood everywhere in Malawi. Now, this, in our view, suggests at the bare minimum that the state should not interfere with the means by which people earn a living. And if it does, it should use the least intrusive means for doing that, so that livelihoods can remain protected in the process. If you look at the response in Malawi, especially under the coronavirus rules that were promulgated, there is a tension between the government's response and the right to economic activity. The totality of the proposed lockdown measures have a tendency to reduce economic activity and thereby make it difficult for people to pursue livelihoods. Indeed, the state wishes to curb the spread of COVID-19, but we think the measures that are being adopted to limit economic activity should only be such as are necessary to combat the public health challenges that COVID-19 presents, and that they should be reasonable and proportionate in relation to the objectives that they are trying to achieve. For example, the coronavirus rules that were promulgated by the government in their full...
Please close, because you're
Certainly.
already over the time.
Okay, pardon me for that. Let me wind up in the next 2 minutes. I was going to illustrate that the rules as currently adopted, if they were implemented in full, they would necessitate the closure of all central markets and the suspension of all non-essential businesses or services, and the closure of all informal trading activities in the country. But at the time these rules were being promulgated, remember, the country had only recorded 3 cases. Of course, there's been more cases recorded over the passage of time, but at the time the rules themselves were being promulgated, the government had officially only recognized 3 cases. This seems to be a mismatch of a response. And also, the list of essential services that were being permitted, that were allowed to operate, the way they were designated excluded other essential services which could have proceeded without enhancing the risk to the population. For example, agricultural production. So all in all, what I would say is that our view is that yes, the government needs to respond to the public health challenges that have been brought about by COVID-19. But we think an adequate and effective response requires the adoption of strategies that conform to the standards in the Constitution. That way, you would protect lives and livelihoods at the same time. It's a balancing act, needless to say. Thank you, Prof, for your attention, and thank you, colleagues, for your attention.
Yes, thank you very much, Professor Nkahata, for this presentation about the situation in Malawi. And I can see in our chat that there have been already some questions, and I think we have at the end enough time to discuss some of your remarks which you have given to us. So let me go forward to Dr. Itumeleng Shale. And now we move from Malawi to Lesotho, which is not so far, by the way. And Dr. Itumeleng Shale is a senior lecturer at the National University of Lesotho. She holds an LLB from the National University of Lesotho, an LLM in Human Rights and Democratization in Africa from the University of Pretoria, and a PhD from the University of Witwatersrand, the WITS University. She has 15 years teaching experience and has a lot of also publications. And I think we just can go on with her presentation about the implications of Lesotho's COVID-19 response framework on human rights and the rule of law. I hope all informations have been right, Prof, and the floor is yours. Please go on.
Thank you very much, and good afternoon, everybody. As stated, my name is Itumeleng Shale, and I'll be presenting on the implications of Lesotho's response to COVID-19. Let me start my presentation by stating that according to the Universal Declaration of Human Rights, it is essential if a man is not to be compelled to have recourse to rebellion against tyranny and oppression, that human rights should be protected by the rule of law. This is taken from the preamble of the Universal Declaration. This states that the rule of law plays a major role in protection of human rights. Hence, this paper seeks to analyze Lesotho's COVID-19 response against both the rule of law and the impact it had on protection of human rights. The paper, as well as this presentation, are divided into 4 major sections. The first section is a description of the situation in Lesotho and how the country responded during the including the legal and institutional frameworks which the country resorted to. Secondly, it's Lesotho's response or compliance with international human rights obligations, in particular, the ICCPR and the African Charter. The third section of the paper deals with Lesotho's compliance with the national legal frameworks. And the last part is on the impact of the response on human rights. Now, dealing with the Lesotho situation and response. Lesotho's response, unlike many countries that responded when the COVID had already hit their land, Lesotho's response was proactive. A state of emergency was declared and a 35-day lockdown imposed prior to recording of any positive cases in Lesotho. A state of emergency was declared on 18 March 2020, but the first case was recorded on 13 May and the first death on 9 July. In the early days of the lockdown, members of the army were deployed to enforce the regulations, but later they retreated when there was a public outcry about the excessive use of force by the army. Over and above the limitation of rights to movement, freedom of association and assembly, the public health regulations also provided for establishment of an oversight body in the form of National Emergency Command Center, commonly referred to as Command Center. A case of Muchochoko was lodged, challenging establishment and mandate of the Command Center. Although the case was dismissed on the ground that the applicant had no locus standi in judicio, after the judgment, the Command Center was disbanded and a new National COVID-19 Secretariat, referred to as NACOSEC, was established. Now, the question which arises is whether this response complied with the rule of law. In order to respond to this question, the paper adopts a two-pronged approach, in terms of which the response is first measured against Lesotho's international obligations, and the second part, it is assessed against the national legal and institutional frameworks. Now, coming to compliance with international obligations, the question that one may pose is, in the absence of domestication of the African Charter and the ICCPR, why is Lesotho bound to the provisions therein? The status or the place of international human rights instruments in the legal system of Lesotho is not clearly stated, in the sense that the constitution is silent, has nothing to say about international law. And the arguments as to why, in the absence of any mention of international law, I take Lesotho to be bound by the ICCPR and the African Charter are stated more fully in the paper. But for purposes of this presentation, I would like to refer to Article 4 of the ICCPR, which states situations under which a state of emergency may be declared, as well as rights from which states are not permitted to derogate. Article 4.1 permits declaration of state of emergency when there is a threat to life of a nation. However, the Human Rights Committee has warned that not all situations call for such declaration and consequent derogation of human rights. While looking at research that has been done against the COVID-19 as well as the current statistics, it is clear that the life of almost all nations are at risk, and therefore this situation may be argued to be covered by Article 4.1. However, Article 4.1 requires further that the measures taken must be strictly required by the exigencies of the situation. That is, not all rights must be derogated from, but only those that respond to the situation at hand. It is argued in this paper that the ICCPR was not complied with in various ways. For instance, while restrictions of the right to freedom of movement and assembly could, according to WHO, contribute to flattening of the curve of infections, such did not need deployment of the army. As such, by deploying the army to enforce the regulations, the focus was shifted from the pandemic to the people, who would then be viewed as part of the problem rather than them being viewed as part of the solution. This was also a violation of Articles 2 and 7 of the ICCPR, which prohibit derogation from the right to freedom from torture, cruel, inhumane, and other degrading treatment. Secondly, despite the situation falling within the ambit of state of emergency under Article 4.1, Article 4.3 mandates states to immediately inform the state parties to the ICCPR of the declared state of emergency. And this is done through depositing such notice with the Office of the UN Secretary General. However, when assessing the situation in Lesotho and in consultation with the Ministry of Foreign Affairs, no such notice has been made to the Office of the UN Secretary General. This thus proves that Lesotho has violated Article 4.3 of the ICCPR. In relation to the African Charter, unlike many other human rights treaties, one of the unique or distinct features of the African Charter is that it has no derogation clause. According to the African Commission on Human and People's Rights, the effect of this is that the Charter does not allow for states parties to derogate from their treaty obligations during emergency situations. Scholars vary, or scholars' views in this regard vary. But what one can conclude is that during the state of emergency, Lesotho could not in any manner derogate from the rights contained in the African Charter, such as Article 5, which prohibits torture and other cruel, inhumane, and degrading treatment or punishment. The restriction of cultural practices also violated the rights contained in the African Charter, as discussed more fully in the paper. Now, coming to the third section, which deals with the question whether Lesotho's response complied with the national legal frameworks. I think it is important to note that as far as the national legal framework is concerned, Lesotho is a constitutional monarchy, in terms of which the 1993 Constitution is the supreme law, and therefore all laws are supposed to comply with the Constitution, failing which they would be declared null and void to the extent of that inconsistency. There is also the Disaster Management Act 1997, the Financial Management and Accountability Act 2011, as well as the Public Procurement Regulations of 2007 and their amendments. Lesotho declared a disaster-induced state of emergency, thus triggering application of both Section 23 of the Constitution and Section 3 of the Disaster Management Act of 1997. It is also important to note that prior to 1997, disasters were dealt with on an ad hoc basis. But since promulgation of the Disaster Management Act, the objective of the act was to establish a body referred to as Disaster Management Authority, and also to make provision with respect to emergencies arising out of disasters, including prevention of disasters, mitigation of their impact, preparedness, response, and recovery measures for the protection of life and property against the effects of such disasters, and to vest responsibility of disaster management in this Disaster Management Authority, as well as in district administrators, where there was a need for district administrators to be involved. The argument in this paper is that at the time when COVID hit Lesotho, there were already existing legal and institutional frameworks which would adequately respond to the pandemic. And therefore, there was no need for establishment of the National Command Center and later NACOSEC. And that creation or establishment of these institutions created a breeding ground for corruption and bypassing accountability procedures in complete contradiction to the rule of law principle. Non-compliance with the national legal frameworks is also highlighted in the case of Mochochoko that I referred to earlier. In this case, a chief of one of the rural parts of the capital city challenged the establishment of the National Command Center, which was the earlier institution established, and the manner in which it utilized public funds. His case was, however, dismissed on the grounds that he lacked locus standi in judicia. However, in Obita, the court stated that COVID-19 fits into the description of disaster as contained in Section 2 of the Disaster Management Act. Thus, the court clearly stated that the relevant legislation for purposes of dealing with the COVID-19 was the Disaster Management Act. Although this case was dismissed, after the case, the government disbanded National Command Center and established NACOSEC. Thus, even though the judgment had specifically made reference to the Disaster Management Act, the government ignored the existing institutions under the Disaster Management Act and what role that those institutions could play in assisting the pandemic. The Disaster Management Act gives a clear guideline as to procedures to be followed where there are disasters, and the management authority is given the authority to deal with such disasters. Therefore, there are challenges that come with establishment of a separate body from what already exists in the legislation. Establishment of NACOSEC in particular brings about several challenges, including non-compliance with the rule of law by disregarding a parliament enacted law and replacing it with an executive order in violation of the checks and balances principle. Secondly, this creates a fertile ground for corruption, misuse of public funds, and non-accountability. In this regard, the paper argues that the government ought to have invoked the normative financial regulations which govern the Disaster Management Authority. In terms of these regulations, the Minister of Finance has mandate to establish a disaster relief fund, which would have a separate account meant for all monies, including donations and funds appropriated by Parliament to deal with the disaster. This account would then be under supervision of the Principal Secretary of the Cabinet. However, in contravention of the Public Financial Management and Accountability Act, as well as the Public Procurement Regulations of 2007, NACOSEC is given excessive powers over public funds without safeguards for accountability. These excessive powers which NACOSEC has, and also the fact that the Minister of Finance feels that in terms of the act is the one who is entitled to put a hand in the cookie jar, which is the fund that is established for response to COVID, has led to clashes between government and this Chief Executive Secretary of NACOSEC, as each feels that they are the ones who are to control the funds meant for COVID relief. The other challenge is that the powers which legislatively, in terms of Section 4 of the Disaster Management Act, are exercised by the minister, are now, through an executive order, transferred to the Chief Executive of the NACOSEC. So this are what some of the arguments that the paper makes as far as the rule of law is concerned. And now, in relation to the principles or to protection of human rights, this paper is structured into two parts, one being the implications on civil and political rights, and the other being the implications on socioeconomic rights. What must be noted is that the ramifications of the pandemic, while they are dire in many, or they are negative in many parts of the world or the entire universe, the situation is made worse in Lesotho because of the pre-existing political instability, poverty, inequality, and a culture of human rights violations. So these pre-existing conditions have made things even worse for people of Lesotho. During the lockdown, human rights were limited in various ways. Rights which in terms of the lockdown regulations were specifically affected include: one, freedom of movement. In the first 35 days of the state of emergency.
Sorry, these are the last 2 minutes, yeah, please.
Okay. Thank you very much, Prof. In the first 35 days of the state of emergency, movement was completely restricted except for essential services. Freedom of assembly was also restricted. As to date, all forms of gatherings are prohibited. Weddings are restricted to 5 attendees. Funerals are limited, and so on and so forth. There has also been violation of the right to freedom from torture, as has been stated that the army was deployed and it used excessive force against members of the public. Also, the right to health and right to life were affected directly. And these are indicated more clearly in the cases of the health professionals association and others. There are 2 cases involving the health professionals, which are discussed in detail in the paper, in which the health professionals challenged the government's failure to provide them with protective clothing in the form, and also fumigation of hospitals and places in which they work. And they even threatened to put tools down as they deemed the healthcare facilities not conducive for their health and deemed them as hazardous. There was also direct impact on the right to livelihood and the right to education. As far as the right to education is concerned, schools remain closed. Private schools are offering online learning, while public schools are not. And what is most important as far as the right to education is concerned is the fact that there are children who come from poor families who depended on the school feeding programs. And in the absence of such food being provided to schools, we are facing further starvation of children who depended on food that is provided in schools. Therefore, in conclusion, this paper argues that in order for Lesotho to respond more effectively and to comply with the rule of law, it is important that the pre-existing legal and institutional frameworks be used when dealing with disasters of this nature. Thank you very much.
Thank you so much, Itumeleng, for this presentation about the situation in Lesotho. It was really interesting, and I think we can jump now from Lesotho to Eswatini. And our next presenter will be Dr. Musa Shongwe, and it's about Eswatini's legislative response to COVID-19 with human rights. Let me just present or introduce you to our presenter. Dr. Musa Shongwe is a senior lecturer at the University of Eswatini, Faculty of Social Sciences, Department of Law, and he's teaching there constitutional law, family law, and public international law. He previously held the position of coordinator of the LLB and diploma in law programs at the Institute of Distance Education. Institutes of distance education are very fine in these times now, distance, when I see this. And he has a postdoctoral fellowship at the South African Research Chair in International Law at the University of Johannesburg. He obtained his LLB from the University of Swaziland in 2008, and he has been, as it was told to me, also held an LLM and an LLD from the University of Joburg, where he was a NRF funded scholar. So very impressive CV. Professor Mshongwe, it's now about you to talk to us about the situation in Eswatini and with human rights.
Thank you, Dr. Wolf. May I just confirm that you can hear me and see my screen?
Yes, you have a presentation, what we see. You shared it on the screen, is it correct?
Yes, thank you, Prof. Good afternoon, colleagues. Let me just quickly thank the University of Pretoria and Prof. Fombard for making this possible, as well as the Konrad Adenauer Foundation. We always appreciate your initiatives. I'm here today to present an assessment of Eswatini's legislative response to COVID-19 and its impact on the rule of law and human rights. Let me begin by giving you a quick overview of the presentation. I will start with a brief introduction to the legal system of Eswatini. It is important in the circumstances for us to understand where we come from in terms of our laws, what informs the legitimacy of the laws we have in place today, especially our constitutional laws. Then I will zoom into the nature of our emergency powers in Eswatini, both in terms of the Constitution as well as under the Disaster Management Act. Then I will analyze the control mechanisms or the oversight mechanisms that exist vis-a-vis those emergency powers. The last thing would be for me to give you just a few examples. There are many in the paper of how the COVID-19 regulations have had an impact on human rights, as well as my conclusions and recommendations. Now, it has been very widely documented how the legal system of Eswatini that exists today can be traced back to pre-independence, that is before 1968, where our governance was based on traditional foundations, and the state of Eswatini has sought to maintain those traditional foundations up to today, even though we do have modern laws governing the state. Now we have an absolute monarchy in Eswatini, and the people are subservient to the monarchy, and that relationship extends to our governance as well. Now, you will note that the Kingdom of Eswatini obtained its independence from the British in 1968. When that happened, we were given a Westminster Constitution. The British assisted us to develop a constitution based on their model. It featured a few human rights, principles of separations of powers, and it limited the powers of the monarchy, even though we did have some sort of democratic governance. The monarchy still retained very wide powers over the governance of the state. But that constitution, as history tells, was overthrown in 1973 when the king that was ruling at the time declared a state of emergency unilaterally and overthrown the 1968 constitution. Now, in doing that, the king indicated that that independence constitution with democratic ideals was contrary to the Swazi way of life and contrary to the way in which the Swazi people have been governed from history, because now there was a new party that had contested elections and had won a number of seats in parliament during that time. And the pro-royalist party, which was dominant at the time, felt threatened, and they felt that the power would then be moved from the monarchy to the people. So history tells us that those were the reasons why the 1968 constitution was overthrown. Now, this 1973 decree was a turning point in the history of Eswatini, because it cemented the royal rule in Eswatini. Political parties were banned, the parliament was disbanded, and the king assumed all legislative, executive, and judicial powers of government. That obtained until 2005, when the state adopted a new constitution. But this new constitution in 2005 also cemented the position of the monarchy. Examples of that are that executive authority in terms of Section 54 is vested on the king. Secondly, supreme legislative authority is also vested in the king. The king can assent to legislation. He can also withhold his assent. That is why some people normally argue that the king's word is law. Now, the king, even though he doesn't have judicial powers anymore, he still holds critical powers of appointment of members of the Judicial Service Commission and judges. That tells us that the monarchy has its hand in all three branches of government. What is even more interesting is Section 65, which says, where the Constitution requires the king to act on the advice or recommendation of any personal authority, he may or may not exercise that function. This has been interpreted to tell us that the king still makes law. The king is not bound by the Constitution to that extent, even though Section 2, subsection 2 says that all, including the king, are bound by the Constitution. So we still have those issues of balancing these two. Now, this has had a major impact on the nature of the emergency powers that are bestowed upon the king in terms of the Constitution. Let me then talk about the nature of the emergency powers. I will note preliminarily that the state of emergency that was declared in Eswatini was not in terms of the Constitution, but in terms of the Disaster Management Act. However, in the Constitution, a state of emergency is narrowly defined. I think other speakers have pointed this out earlier on, that the legislative drafters at the time couldn't predict situations such as the COVID-19. So they only mentioned in our case when the country is at war, when there is a natural disaster, or when there's a terrorist threat or an imminent threat, that is action taken by anybody that poses a serious threat to the country in terms of Section 36. So a pandemic wasn't foreseen by the drafters of the Constitution. Now, Section 36 gives authority to declare a state of emergency to the king, acting on the advice of the Prime Minister. But as we have seen on the previous slide, the king is not bound to follow the advice of the Prime Minister in any case. But the prerogative to declare a state of emergency by virtue of those grounds mentioned in Section 36(2) is vested on the king. Now, the consequence of that would be the suspension of some of the rights and civil liberties when the country is on a state of emergency. However, we do have a provision on non-derogable rights, which states that if the country is in a state of emergency, you cannot restrict or limit or take away the right to life, equality before the law, security of the person, fair hearing, freedom from slavery, torture, cruel, inhuman, or degrading treatment or punishment, as well as access to justice. Now, there is a question as to why wasn't Section 36 invoked. The first reason, as I have mentioned, was that in my view, the COVID-19 pandemic it doesn't fall under the ambit of Section 36. Secondly, excuse me. Secondly, I believe that not invoking the constitutional state of emergency was to a certain extent safer for human rights, because there is no telling what that proclamation that the king would have made when declaring a state of emergency in terms of the constitution, what would have been the terms of how, to what extent would have human rights have been protected if it was a constitutional state of emergency. Now, I am saying this because in the history of declarations of state of emergency in Eswatini, it has been a very dramatic unfolding of events. The 1973 one, we have seen what happened, and then we have had other states of emergency being declared in the pre-constitutional era, whereby it was in response to either drought or the worsening economic and health situation caused by HIV and AIDS in Eswatini. Now, I also argue that the grounds did not cover the pandemic, the constitutional grounds did not cover the pandemic as a disaster. So I think it was proper for the state not to declare a constitutional state of emergency. So what happened in Eswatini on the 17th of March this year is that the Prime Minister invoked Section 29 of the Disaster Management Act, which defines a national emergency as a disaster, a state in which normal procedures are suspended and extraordinary procedures are adopted in order to avert a disaster. Now, a disaster is defined in the same act as widespread human and environmental losses. So from a generous interpretation of that, we can say the COVID-19 as a public health pandemic concern falls under this type of national emergency. The Disaster Management Act empowers the Prime Minister, acting on the advice of the Deputy Prime Minister. It was concerning then on the 17th of March, when the declaration by the Prime Minister was couched in the terms, as I have quoted there, to say the Prime Minister has been commanded by His Majesty the King and Ingwenya. Let us also note the King, the terms, commanded by the King and Ingwenyama. These, even though it refers to one person, the King and the Ingwenyama in terms of the Constitution have separate capacities. He is called Ingwenyama in the traditional realm and referred to as the King in a different realm, as it is mentioned in the Constitution. So when the Prime Minister mentioned that he had been commanded by the King to exercise powers that are already given to him and to him alone under Section 29, it was concerning as to issues of the rule of law. Does the King have the mandate to overreach to the powers of the executive? There is no mention of the role of the King or royal commands in Section 29, and the Constitution also doesn't give any leeway to His Majesty to command the Prime Minister to exercise powers already conferred on him by statute. However, some people argue that because the King is the head of the executive, the King has all executive powers, then this is unquestionable. It is questionable academically because what ensued afterwards, we have seen some examples I will give later on, whereby state law enforcement organs or persons have violated some rights, arguing that we are in a state of emergency and this treatment is justified. I will highlight those examples later on. So when we look at the emergency powers in terms of the Disaster Management Act, we will find that from the reading of the Act in general, the powers are centered on the Prime Minister's office. The Prime Minister works with the Deputy Prime Minister as well as the Cabinet Ministers who form the Disaster Management Council. Now, the role of the Cabinet, the Ministers, is advisory, is for policy development and operationalization plans. We also have a Disaster Management Council, Now, I'm saying this is an inclusive technical advisory organ because under the Tinkhundla system of government, power devolves from central government to Tinkhundla, that is constituencies, to the grassroots level. It involves regions, it involves chiefdoms, it involves even civil society, and all the way to the bottom. So the key persons are involved as part of the technical advisory organ. They have a role in the development of the regulations. And then we have an implementing body, which we call the Disaster Management Agency. Excuse me, the powers, the Disaster Management Act of 2006 primarily caters for the emergency response and plans for mitigation of disaster-related harm. From my reading of the Act, I have found no human rights considerations or very limited human rights considerations in the manner that the provisions have been framed. Instead, I have seen apparent dangers or possibilities for violations in the wording of the Act. An example is Section 32. In this section, it is said that the Deputy Prime Minister, who has the responsibility of developing the guidelines, which will ultimately be adopted or accepted by Parliament, has discretion to act without authority from either the Prime Minister or the Parliament. Now, he has authority to control the movement of persons, the reallocation of resources and public utilities without authority. The question is, how do we limit, how do we control those powers? How do we ensure those powers are not arbitrarily exercised? There are no oversight mechanisms that I have seen, either from the regulations or from the Act itself. Secondly, we have also in Section 32, whereby the police force and the army, as well as members of the correctional services, can be called in and they are entitled to conduct search and seizures without warrant, as long as the state of the national emergency is in place. This is another example. So the powers of the Deputy Prime Minister to develop or draft the regulations in terms of Section 44 can be delegated to somebody else within the public service. Section 44 talks about delegation of the power to make. So the question is, can power from delegated legislation be further delegated? It appears as though there are limited safeguards on the prevention of abuse of power in the manner that these provisions have been expressed, and the prevention of ultra-vires action. The consequence of this, as we will see from the examples that I will highlight, is that we have seen incidents of undecisive governance, incidents of back and forth regulations. One regulation today changed tomorrow, the following week, something different in the governance of this COVID-19 legal framework. Now, it has resulted in uncertainty of our law and the people not knowing what is right from what is wrong.
Prof,
the control.
Please round up your presentation in the next 2 minutes.
All right. The control mechanisms that exists in a situation of a constitutional state of emergency declared by the king would be that there were no restraints on the powers of the king. And because Section 36 of the Constitution wasn't invoked, one can argue that the derogation of rights during this national emergency has no legal basis. There is no special oversight mechanism on the emergency powers created by the Disaster Management Act. So what we have are the general safeguards in our law, such as Section 38 on non-derogable rights, Section 35, the right to approach the High Court for a remedy, as well as approaching the Human Rights Commission, even though it is not operational yet because of the lack of an enabling legislation. Parliament does have limited oversight over the implementation of the regulations as well. Now, we have had issues whereby travel restrictions have had an impact on the ability of persons to access healthcare and to access their livelihoods. The paper also highlights that the closure and opening of schools have had an immense impact on the right to education. The distance education programs that have been implemented have not been accessible to all. We have had cases of academic exclusion due to the lack of internet or gadgets or accessibility to the network in general. We have also had cases whereby the ban on wholesale and distribution of alcohol has been challenged on the grounds that the fault lies with the end user, not the value chain. Now, the end users are the ones who are seen to be irresponsible in their consumption of alcohol and hence increasing the incidence of COVID-19. But the value chain has complied with the regulations. So let me conclude by also mentioning just in passing that we have seen a restriction of the religious freedoms, the regulations concerning gatherings, equality before the law. There's been unequal enforcement of the regulations. State events have been preferred to have more people, yet private gatherings or church gatherings have been limited to 20, sometimes 50. So there is unequal implementation of the law, where there are issues with social protection. People haven't had access to social relief grants adequately, even if they are being implemented. The protection of vulnerable persons has also been a major issue highlighted in the paper. Now, lastly, let me talk about the right to life. We have had an incident whereby the minister has allowed a positive patient, a COVID-19 positive patient, to refuse treatment, yet the regulations specify that the ministry and the disaster management agency have a responsibility to make sure that they quarantine and they isolate a person for the benefits of the rights of others. But the ministry has taken the position that a person has a right to refuse treatment. Now, in this context, the entire nation is endangered, or at least those in immediate contact with this particular patient. That has also been an issue. So basically, my recommendations are centered around balancing the response measures with public health objectives. Let me end there for the sake of time. Thank you, Chair.
Okay, thank you so much, Prof, for this interesting and enlightening presentation. And we can go on now. We will also have to discuss many things, I'm thinking, later. But let's now go forward with Mrs. Chantal Moyo. Mrs. Chantal Moyo will speak about urban spatial inequality and access to water in the wake of and beyond COVID-19. When I like to introduce Mrs. Chantal Moyo, when I read about her CV, I think she's a kind of colleague of me, because there is written that Chantal Gloria Moyo is a current Konrad Adenauer Stiftung Strong Cities 2030 doctoral researcher under the South African Research Share, and it's about cities, law, and environmental sustainability. Her scholarship is dedicated to research addressing current contemporary African challenges in environmental, energy, and urban governance law. She is a registered legal practitioner and has lectured modules in environment law, law of delict, and intellectual property law at institutions at the University of KwaZulu-Natal and at the Great Zimbabwe University. Chantal, you are warm welcome to you, and we look forward to your presentation. The floor is yours.
Thank you very much, Prof. Afternoon to everybody. Can I please get confirmation that you can see my screen?
Yes, it is. You have a presentation on the screen.
Yes, Prof. Thank you very much. Like I said, good afternoon, everybody. My name is Chantal. I am going to be making a presentation this afternoon on urban spatial inequality and access to water in South Africa in the wake of and beyond COVID-19. As you'll see from my topic, that my paper is very specific to to one area, which is access to water in South African townships or urban areas. My paper is a bit different from the other presentations because it doesn't really focus on the extent to which the state has gone to curtail human rights amid the COVID-19 pandemic, but rather it questions the adequacy of some of the measures that the state has put in place in terms of access to water rights to minimize and curb the spread of COVID-19. Now, the paper is pretty detailed, but I will not go into the crux of it for the sake of time. So my presentation will highlight the most important aspects as far as my topic goes. Okay, so spatial inequality in urban areas is basically a result of income inequalities between households. And this is or can be attributable to various factors such as initial conditions, history, institutions, endowments, and trade. For example, if you look at cities in South Africa like Durban, like Cape Town, the cities have been developed because of their function as trade ports. And if you look at cities like Johannesburg and Pretoria, you can see that their development can be attributed to mining activities. And the same token, lack of development in other parts of cities around South Africa has historic origins, and especially in townships. Now you'll see that a history of apartheid that thrived on racial segregation resulted in these areas historically having minimum funding and lacking infrastructural development. And this, the consequence of this is that the basic services has been limited in such areas. Now, just a quick look at the examples of what we're talking about here. A picture on my left is a picture of Guguletu, one of the oldest townships in Cape Town.
Chantal, it's a bit difficult to understand you, to hear you. Is your mic?
And the picture on my right is the picture of an aerial example, an aerial view of an example of a township, a typical township in South Africa. And these are the cities, these are the places in cities that this paper looks at and this paper considers. And pardon?
Chantal, we can't hear you.
Can you hear me?
We hear you. It's very difficult to understand you. Is your microphone okay?
Can you hear me?
Hello?
I think she's out.
She's out.
Yes. Don't think she's...
That is a pity. So how do we go on now?
Let's just give her a few minutes to see if she will rejoin us.
Okay.
Meanwhile, the previous presenters, I think there are some questions in the chat box there for you to take note of.
We can already go on with this, but let me just see where we are here now. Okay, let me take the chance to ask our previous presenters from the different countries. Just one question from my side, because before we look at the other questions which have been in the group chat. My first question is there in any constitution a kind of a determination about the state of emergency? So how is a state of emergency handled in the constitution? When you declare it, is it unlimited until somebody declares it for finished? Or is it, does it need to be approved every 3 months? Or just how are the states or the constitutions handle the proportionality of this state of emergency?
In the case of Eswatini,
yeah.
Hello?
Yes, we understand you.
Yes. In our case, the state of emergency in terms of the constitution cannot exceed a period of 3 months, but it can be extended by the king reinstating or extending the period in consultation with parliament. So it will be the king and parliament that will be leading the extension of the state of emergency. However, it is not an indefinite situation. Unlike when before we had the constitution in 1973, when that kind of state of emergency was declared, it subsisted until 2005. So there was no control during that era.
Mm-hmm. Okay, thank you. Something
as
from
far as
Lesotho?
Lesotho is concerned, Section 23, subsection 5 of the Constitution gives Parliament power to declare state of emergency for 6 months, and at the expiration of the 6 months, it may extend it for a further 6 months.
Mm-hmm.
So the current state of emergency ends at the end of October.
Okay. And okay, how is the situation in Malawi?
Yeah, so in the case of Malawi, the president declares the state of emergency in conjunction, actually acting with the approval of the Defense and Security Committee of the National Assembly. Once he does that, it goes into operation for an initial 21 days. And it lapses after 21 days unless it is extended, and it can only be extended for 3 months at a time. And that has to be done by a resolution of the National Assembly, which must be supported by at least 2/3 of the members of the National Assembly. But the Constitution also expressly says the High Court retains competence to hear applications challenging the validity of any declaration of a state of emergency or any extension of the state of emergency. That's the framework in Malawi.
So that sounds very strict. Thank you so much for this information. And then let me ask our presenter if she is listening. Can you hear me, Chantel? Chantel, can you hear me? It seems to be not. So if Chantel can't hear me, then we can maybe go on with the questions which have been asked already on our chat room. What was it? Let me check here. There was one question. That is not Chantel, that was another one. Let me see. There was a question by Philip Muiziri to all of our presenters. The question is, does the fact that government in Malawi went ahead to set up structures before the necessary legal framework was in place reflect an administrative oversight, sorry, or is it a reflection of a culture that governments sometimes are inclined towards? Do you understand the question?
I think I do, but the history of my chat got a bit lost because I was disconnected at some point. But let me try to explain. So like I pointed out, Malawi declared the state of disaster, not a state of emergency, a state of disaster before we actually confirmed infections, confirmed cases were recorded of COVID-19. In the paper, we postulate that part of the reason for the type of response that happened in Malawi is to be found in the political dynamics that were at play in the country. So some of it we think wasn't really a question of a response, a pure response to a public health emergency. You will recall that in February, the High Court had annulled the presidential election from last year. And that judgment was confirmed by the Supreme Court, which meant that the country had to hold a fresh presidential election within 150 days. What has happened in the country is that if you look at the number of cases that were being announced, COVID cases in the time pending the presidential election and the time after the new president was elected, there's a huge difference, which seems to suggest that perhaps the numbers were not being correctly disclosed before the fresh presidential election, when everybody was focused on preparing and gearing up for the presidential election. But that afterwards, more attention has been brought to the public health emergency that is at play in the country, and maybe more honest and truthful numbers are coming out about the state of the crisis. So I think the response was conditioned in part by the political realities in the country at the time, and even up to now, I think the response has been conditioned by that. Even the new rules that I said were promulgated last Friday, I think this is also because the new regime is trying to carve out its own response in relation to this COVID response, not just to inherit the past response from the other regime. I hope I've tried to clarify in part some of the things that were asked for.
Yes, thank you so much for this response. I think it was very efficient. If there are any other comments to this question, if not, I would like to go on to another question, which was about the presentation about Eswatini legislative response by Dr. Musa Shongwe. And the question is it correct, therefore, to assert that the COVID-19 pandemic has aided and abetted the contraction of democratic space in Eswatini? This is a question by Philip Muziri.
Thank you, Chair. I would say that we have a Swazi conception of democracy. Our kind of, we refer to ourselves as a monarchical democracy. So I always have an exceptional answer when it comes to democratic questions. In our context, we refer to the engagement of all stakeholders within the levels of governance, both traditional and modern, as public participation and public consultation. That is our form of democratic governance, or our understanding of democratic governance. Everybody has an input, everybody has a say in what ultimately becomes law. The problem comes when it is time to ensure accountability of public officers, of our ministers, in what has been agreed upon. We have very limited space for ensuring accountability, but simply by the fact that all public officers have, the appointing authority is His Majesty. They are serving His Majesty. Are they serving the people? No, it is very rare. So other than judicial review, other than a resort to our courts, I would say that we do not comply with the global understanding of democracy. So the lack of checks and balances on emergency powers is a problem. The development of guidelines by ministers who do it without sound scientific basis is also a problem. So we have those kinds of issues where wide powers are given, broad powers are given to ministers to exercise their functions arbitrarily. Sometimes we have highly punitive measures, such as the use of the military where it is not necessary. Then it ends up in some human rights violations. So those are the issues I think are pertinent when it comes to the question of democracy, but the state has the duty to protect its citizens. So in the context of COVID-19, we can say that the state must exercise that duty reasonably, proportionately, and in view of the disparate effects of the measures on the different people statuses in society. We have people who in low wage employment. We have people who have been affected. You know, for rich people, the COVID-19 regulations have just been an inconvenience. But for people whose livelihoods are based on daily struggles, let me give you an example of people who are living along the borders, who have to cross on the informal crossing lines just to make a living on the other side and come back, to access education on the other side and come back. Everything is shut down now. What are they going to do? Yes, it is illegal to cross the border at those informal crossings, but it is an established livelihood, because before COVID-19, those informal crossings were allowed. But all of a sudden, it is closed by both states, South Africa and Eswatini, for example. So those are the issues we think about. Thank you, Chair.
Yes, I think we know these circumstances. I mean, we in Kenya, we have also this problem between Kenya and Uganda, and our people living at the border to Tanzania, which are not allowed to cross, and so on and so on. It's really a very common issue. But there is another question for you. And before
I think Chantal is back.
Yes, but let me just finish this question to Dr. Musa, and then we go back to Chantal. There was a question, what was it? You outline challenges that are presented by the fact that the king holds and can exercise certain powers that could threaten democracy. It appears to me that such was the state of affairs before COVID-19 pandemic. Would you say, therefore, that COVID-19 has exacerbated the pre-existing democratic deficits?
Yes, that is the one I was answering.
Oh, you did it already, sorry.
Yes.
And I was wrong. Okay, then let's go on. Chantal is already back on our screen. And so she's telling it stable enough. Chantal, you have still 12 minutes to go on. So please take your time and give us your presentation. Go on, please. Chantal, we like to hear you. We would like to hear you. You have some nice slices here, but Chantal, do you understand me? Is anybody understanding me?
Chantal, can you unmute your microphone? I'm trying to do it on my hand and it doesn't work, so.
Okay. Can you hear me now? Can you hear me, Prof?
I'm very sorry. So Chantal, can you hear me? Actually, maybe it's on my end, but I don't know what the others are hearing, but I actually can't really hear you in a proper way. Chantal? Treasure, can you help us?
Is it possible she tries it without the PowerPoint presentation?
Yeah, whatever, it belongs to her.
Yeah, that's what I was going to suggest. Let her leave out the PowerPoint presentation and it will help enhance the quality.
So Chantal, can you hear us? Don't share the screen. Don't give us your PowerPoint presentation. Just talk to us. Can you hear me? Where is she? Western Cape. Huh? So we have always issues with Western Cape. Chantal? I think it doesn't help, Charles. Charles?
Yes, I think we could continue with our discussion and hope that she sorts herself out and catches up with us.
Yes.
But can I make a comment?
Another question. Let me ask the other question to all presenters. That is a question by James Luyomboya. And his question to all presenters is about how possible is it that the emerging draconian tendencies explained will outlive the COVID-19 era? And if they shall, is it to do with the mode or legal mode has been adopted by the various governments in responding to the pandemic? Maybe we can get an impression or remarks to this responses to these questions by our presenters. Shall we start with Professor Mwiza, you and Kahata?
Sure. Speaking from the Malawian perspective, I remember I said the government promulgated fresh regulations just last Friday. So I do not think that COVID absent, such measures would still be in place in Malawi. And here is my motivation for this thinking. The moment the government first proposed a lockdown, 3 challenges were lodged before the court. And in at least 2 of those cases, the court granted leave for judicial review and also questioned the methods that had been adopted by the government in terms of responding to this pandemic. These regulations that were promulgated on Friday, my hunch is that in the next 7 to 10 days, somebody will also lodge a judicial challenge, because one of the things that they have done is that by restricting gatherings, they have restricted again religious gatherings without an equal restriction extending to entertainment places. So there are still some anomalies within these rules, within the new regulations. So in my view, I think this kind of regulation would not survive the demise of COVID in the case of Malawi. And I think in the short term, we'll see further judicial challenges questioning the legality of some of the measures that have been adopted to deal with the pandemic. Thank you.
Yes, thank you so much. Dr. Itumeleng Shale, some impressions from your side?
As far as Lesotho is concerned, I stated earlier that there was only one challenge in relation to establishment of the NECC, and that challenge was unfortunately dismissed. And I think that challenge was somehow a discouragement to people who would want to challenge government further. Basotho are a very litigious society, but the litigation remains amongst themselves. They are very reluctant to sue government. Hence, we only have 3 cases in relation to the COVID, the 2 being by the health professionals and 1 being this one that was dismissed. So taking into account what has happened post that case, chances are, even if the current regulations do not persist post-COVID, but the tendency of establishing institutions such as NACOSAC beyond COVID is highly likely. So chances of these tendencies taking place post-COVID are highly likely. especially because the person who attempted to challenge them his case was dismissed on the basis that our legal system does not allow public interest litigation and so on and so forth.
Okay, thank you so much. And then Dr. Shongwe, what is your?
Yes, thank you, Chair. In our case, Eswatini, I think we are also at a risk of having long-term effects of what is unfolding. Lesotho is lucky. We only have one case that is before the courts today. That is from the health workers. The Liquor Traders Association has engaged the minister. They are yet to decide to take the matter to court. They are yet to enroll that matter to court. But what I'm saying is we can anticipate some major structural damages on the rule of law and human rights in Eswatini, because what is an exception today has been known in the history of Eswatini that then becomes a culture. People of Eswatini have a tendency of accepting things and not challenging authority. It is in our being. The 1973 decree, only a minority of people challenged it. Even today, the people who are working towards or fighting for democratic reforms are a minority. The rest of the nation just accepts things as they are. In 2018, we woke up, it was Swaziland, the following day it was Eswatini. Nobody challenged that except for one human rights lawyer. So we are in extreme danger that the abuse of power under the guise of the COVID-19 regulations might persist. So we are experiencing those issues. Our laws are unpredictable. The hasty passing of regulations without consulting the public, without making sure that they are based on a credible evidence, makes our laws uncertain. We also have issues of censorship of journalists. There are journalists who report on COVID-19 issues and they face persecution. We are experiencing those issues, and in my thinking, we will have a ripple effect.
Okay, thank you so much. And May, you can go on with a response to the next question, which is from Privilege at all of you. And the question is, do you think some of the African countries implemented the state of emergency based on South Africa's announcement without putting some measures in place because some regulations have not been in line with constitutions? You want to start again, Dr. Shongwe?
Yes, in our case, the evidence was clear. Actually, they normally say when South Africa sneezes, Swaziland catches a cold. So ours was reactive. Every day we are reactive to what South Africa does. They shut down alcohol, we shut it down this side. They do this, we do that. So there is overwhelming evidence of us following the South Africa. When the state of emergency was declared, there was only one reported case in Eswatini, yet there were many in South Africa on the 17th of March. So the threat had not yet been established here. Some people thought it was immature. Some people thought, let's just take that. That is the reason why ours was called a partial lockdown, not a full lockdown, such as what happened in South Africa, where people were forced to stay at home. For us, there were some operations that were permitted within the state and within public and private institutions. So I would agree with that assessment.
But just imagine you would have not prohibited alcohol, Eswatini would be overrun by South Africans. You couldn't secure your borders anymore.
Yeah, that is true.
So let's go on with Dr. Shale. Itumeleng, what is your
The situation in Lesotho is exactly as it was in Swaziland, that even to an extent that even when President Ramaphosa had a speech at 8 p.m., we knew that the following day our own prime minister will make a speech.
Okay.
The only thing that was disconcerting to the people was that when South Africa decided on the measures that it would put in place to ensure that people who are homeless are are accommodated during the period, to ensure that there is financial assistance to businesses, taxes, and so on, that is where we did not copy. Where finances were involved, that is where we retained our sovereignty and did not copy South Africa. But when alcohol was closed, we did so. When there was total lockdown, we did so as well. And unlike Swaziland, which had at least one case at the beginning of their lockdown, ours was a total 35-day no movement lockdown with no cases whatsoever.
Okay, thank you so much. And then now Malawi. Malawi is not a neighboring country of South Africa, but was that anyway also feeling a kind of influence or dominance of South African politics?
No, I don't think so. I think in terms of the response, I wouldn't say that it has been influenced by developments in South Africa. And I have to emphasize there that in Malawi, there's a distinction between a state of disaster and a state of emergency.
Yeah.
What the government proclaimed was a state of disaster, which is a less restrictive condition, a legal situation, than a state of emergency under the Constitution. The challenge was that when they proclaimed the state of disaster, some of the measures that they introduced indeed raised concerns that they were acting as if they're under a state of emergency. That is where the problem and the genesis of some of the legal challenges occurred. The threshold for proclaiming a state of emergency is far higher than the threshold for proclaiming a state of disaster. And in any event, I should also highlight that in Malawi, we have not had a lockdown. We might still have it in the future, but we have not yet had a lockdown since the pandemic started. Since the attempted lockdown was aborted by a court order, and an attempt to reintroduce it via the back door, if I could call it that, was also stopped before it was rolled out. So I wouldn't say there's been a lot of South African influence in terms of the response. Thank you.
Okay, thank you so much. So we still have 15 minutes for the session. May I ask again, Chantel, if she is available to go on with the presentation? Chantel, can you hear me?
Can I make a quick comment?
Okay, please.
Yeah, I totally agree with Professor Carter. In fact, I was going to say that a short while ago. If you look from a comparative perspective, you will see that most constitutions, they refer to a state of emergency, state of disaster, state of siege, state of constitutional need, state of alert, state of alarm, as if these were different things. But when you look closely at the way they try to define these different concepts and distinguish between them, there's hardly any. At the end of the day, which one they choose depends on, is really determined by political convenience rather than anything else. For instance, if you look at those countries which declared a state of disaster, they could jolly well have declared a state of emergency. So they choose one or the other depending on how they want to react to the situation and limit a scrutiny, whether it's parliamentary or otherwise. Thank you.
Chantel is back.
And are there any other remarks from our side, from the panelists or from other people who are watching, following this discussion?
Chantel.
I have no more written questions. Or is Chantel on board again?
Yes, she's there.
And we can understand you, Chantel. Can you understand me?
Prof, can you hear me?
Yes, now we can hear you. Did you get that you may skip your presentation by sharing the screen and just talk to us without this presentation, which looks nice, but maybe takes too much power of our whatever an online meeting, consumes too much whatever data.
Yes, I can certainly do that, Professor.
Yes, then please go on, Chantel.
A quick apology. I'd like to apologize. I'm connecting from Zimbabwe, so I'm experiencing a lot of technical difficulties. But hopefully I'm stable enough now to deliver my presentation. Okay, so my presentation, like I was saying, my presentation is a bit different from the other presentations that we've heard so far, because in as much as it doesn't dwell much on the extent of the state's power in curtailing human rights in an effort to minimize the spread of COVID-19, it rather interrogates the aims of providing access to water and curtailing the spread of COVID-19. As an aside, I like what Dr. Musa, the restrictions on COVID by many states is just an inconvenience to rich people. But what about poor people? So this presentation is going to interrogate whether or not the responses by the state in South Africa relating to COVID-19 furthers the right to water for many residents who are in townships, which historically is a place where access to water is a challenge, not only right now because of the COVID-19 pandemic, but all across South Africa, all across South African cities. We've had on the news, we've had in different forums of protests whereby citizens go on, take to the streets because their taps have run dry for longer than a month, for longer than 2 months. So what does this mean amid amid the COVID pandemic? Now, essential to the prevention and the minimization of the spread of COVID virus is the washing of hands under running water with soap for at least 20 seconds. Now, this is one of the World Health Organization directives. Obviously, as we know that there are other measures, but my paper focuses specifically on this one measure to curtail the minimization. Now, when I say that access to
Chantel has disappeared.
Sorry, Chantel disappeared again. I think it will not help anymore today to go on with her. Sorry to say.
Can you hear me now?
Yeah, Chantel, but we always need to start again.
I'm back, Prof. I understand, Prof. Is it possible for me to make the presentation first thing tomorrow morning?
We can ask Charles if there is any space, but then you need to travel to a country where the internet is better. Overnight.
Well, we will see. We will see if our friend, Mr. Peter Wendell, can accommodate you. But yes, I think the topic you're talking on is very, very important. So we will try to see how we can accommodate you tomorrow morning.
And
thank you very much, Prof.
Maybe Chantel, I don't know what is Charles thinking about that, but it would be nice if you also maybe can send, as long as you haven't done this, to Charles and others, that we can distribute this presentation, because also if it would not work, that we can listen to you, I would really appreciate if we can watch your presentation, because it looks very good.
Thank you very much, Prof. I'll definitely do that.
Yes,
yeah.
Please send it to Trésor. Send it to Trésor.
Okay, thank you, Prof. I'll definitely do that before the end of the day.
Okay, cool. Charles, I think I don't see any further questions. Or am I wrong? No.
Yeah, I think it looks like.
I see some comments, but no questions, to be honest. What do we do? Are we done? What
I think we could adjourn for tomorrow. Let me take this opportunity to thank you as moderator. I think you've been very up under challenging circumstances You've seen us through it. I want to also thank the presenters, Professor Nkata and his co-author, Dr. Itumeleng Shale, Dr. Musa Shongwe, and particularly Chantal Moyo. I think she's gone to extraordinary lengths to actually talk to us, but the technology was not on her side, but we really appreciate her effort. I will want to strongly encourage everybody, particularly the paper presenters, that they should be with us again tomorrow, because I find many of the comments that are coming up, many of the questions that are coming up, very eye-opening, very useful going forward. So please try to join us again tomorrow, and we're hoping that there will definitely be very interesting presentations. They will be thought-provoking, and they will help us to get a clearer idea of the way forward. So thank you all very much. Please try to join in, I think, by 10 minutes to 10.
Yes, that would be great. Thank you so much, Charles. And then good luck for going on tomorrow. And maybe also Chantal has a chance to repeat her presentation. Okay.
Yes, I'll talk to
us, I also say thank you, and I will be replaced tomorrow by my colleague Peter Wendo, which is probably well known by many of you, and he will moderate the first session tomorrow morning. Okay, bye-bye from Kenya.
Bye-bye, everybody.
Lesotho.
Bye from Nigeria.
Bye-bye.
So please join us again. We look forward to all of you, and I will prepare a virtual breakfast for everybody. So please be there. I'll make sure you enjoy it. If you've not had that experience, then look forward to it. It will be there.
Thank you, Prof. Thank you, Chair.
Okay, thank you.
Thank you, bye.
Bye.